And we are live on Facebook. It is the Baldani Law Group. We're here in downtown Lexington. As always, I am your host, Bradley Clark, and I'm here with my partner, Abe Mashney. Abe, how are you doing today?
Pretty good.
All right. Today, we've got a couple topics we want to talk about. It's really a bunch of topics kind of put into one, but it's the life cycle of a felony case in Kentucky State Court. In particular, I think we're going to focus on the procedures in Fayette County, but we may kind of keep it more general just so it can help as many people as possible. That being said, Abe, tell me a little bit about your experience with felony cases.
Well, I handle a lot of them. We get into cases in the pre-investigation stage where the law enforcement is investigating felony cases and no charges have been filed. We also get into it in district court and as well as in circuit court after indictment.
Okay, yeah. So what makes something a felony? Let's start with that. I think that's kind of foundational. What is the definition of a felony?
Sure. So a felony is going to be any criminal charge with a punishment greater than 1 year and 1 year above. And so there's different classes of felonies. You have here in Kentucky Class A, B, C, and D, whereas a Class D felony normally ranges 1 to 5, although there's some that are 1 to 3. There's a Class C felony where it's 5 to 10, Class B felony 10 to 20, and then the most serious Class A felony where you're looking at 20 to life.
Okay. What types of crimes are we talking about? What are some felonies that people might have heard of?
A lot of trafficking, drugs, theft over $500. You've got any type of possession of narcotics, whereas cocaine, heroin, fentanyl. You have a lot of sex abuse cases, rape, robbery, burglary. Those are the big ones.
Okay. If you're just joining us, we're talking about the life cycle of a felony case here in Kentucky. Right now, we're kind of focused on the investigation phase. Well, just to go ahead and give a little bit more for the people at home, we talked about what are felonies. If something's not a felony, what kind of crime is it?
If it's not a felony, it's either a violation, which is just punishable by fine, or you've got misdemeanors. And misdemeanor is going to be any type of criminal offense that is lower than a year. So up to 12 months. You have a Class A misdemeanor and a Class B misdemeanor. So Class B misdemeanors are up to 6 months, whereas a Class A misdemeanor is going to be 12 months.
Okay, I think that's...
Or 90 days.
90 days, yeah.
Sorry.
It's okay. You're on the spot. So, and people, I get this question a lot. Like, I'm pleading guilty to DUI. Is that not a lot, but some of my clients do plead guilty to DUI. So people ask me, is this a felony? Is DUI a felony in Kentucky?
It's only a felony if it's a 4th or greater DUI within 10 years. And so that law just recently changed. It used to be a 5-year look-back period, but now it's a 10-year look-back period.
Okay, great. Let's talk a little bit now. Let's go back to that idea of the investigation phase. And what do we mean by that when we talk about the investigation phase? So
normally either law enforcement got a tip, somebody filed a report, or it's criminal activity can get on law enforcement radar in a lot of different ways. There could be a task force that's specifically geared toward a specific criminal activity, or a citizen may file a police report in which a detective is going to investigate. But at some point, law enforcement has been made aware that there could be some criminal activity. So they're going to assign it to an officer that's going to start investigating, whether they do interviews, forensics, testing. There's a wide range of them actually investigating. They could be looking at books as far as any type of theft. And so they're just going to try to find out more information to see if there's going to be probable cause to go forward with a charge.
Okay, and why is it so critical that you get your lawyer involved in the investigation phase?
Well, a lot of times your lawyer can prevent charges from actually being filed. If you don't have, first off, anything that the subject of the investigation, anything that they say to law enforcement, that can and will be used against you. And so you're doing yourself a disservice by participating in that, because you could give them information that you think is right, but maybe you're just off on one thing, and then they think that you're lying. And so by hiring an attorney, you can have a voice in the investigation. You can get your side heard and hopefully try to prevent it.
Yeah, and I guess from personal experience, I'd just say, sometimes if you get into the investigation phase and it might be a financial crime or it might be a question of did you knowingly take the money or misappropriate it, you may be able to pay a civil penalty or make some sort of contribution to restitution to make it not get charged criminally, keep it kind of as a civil matter. And that's important because, criminal versus civil, the difference is do you owe somebody money or do you go to prison potentially? And so a lot of times you'll see these kinds of arrangements where somebody will be being investigated and they'll agree to pay back a certain amount of money to avoid certain charges or maybe charges altogether. So, I can't emphasize it enough. I think it's absolutely critical if you believe you're under investigation, even potentially, maybe even if you know that you could be under investigation, you may want to reach out to a lawyer, retain them, say, hey, this is what I've got. What kind of the lawyer can go in and they can say, well, this is your exposure. This is what you can maybe do to mitigate it or maybe even get out of it. The idea of the crime of attempt, the offense, you can renounce your attempt to do something. And so you can even make your conduct no longer criminal in certain contexts. And a lawyer could help you do that. And I think ultimately some of the greatest results I've gotten are the cases I can't talk about because they never got charged. And, that's the way it should be. Lawyers should keep confidentiality. But I think some of my greatest, if not most of my greatest successes are the cases that never even went to court.
So how many calls do you get for Joe Smith saying, I've been called into the detective's office. They want me to come down at 2:00 this afternoon. What should I do?
Yeah, I think that's a good question. I get those pretty frequently. Once a month, maybe not quite that, where somebody has been detained by the police or they have maybe not even been detained. They've just been asked in for questioning. And, you'll get the call. Sometimes I'll get the call from the police officer that they've got my cell phone. They'll say, hey, I've got Joe Smith down here. He asked for a lawyer. He said you're his lawyer. Will you come down and talk to him? And I'm like, yeah, I can be down there 5-10 minutes. And I'll walk over to the police station. And, the first thing I want to do is I want to separate my client from the officer. Or prospective client. I want to get him out of that room that records everything and talk about what's going on. And I'll say this. I've had a lot of good experiences, particularly with Lexington Police, and not other police departments too, but particularly with Lexington Police, where my clients have been very forthcoming and, they've gotten benefits for it that they wouldn't otherwise have been if they'd been so cagey. A lot of people think that what we do as defense attorneys is pretty simple. It's just tell them to shut up, tell them to lawyer up, tell them to be quiet. And it is that sometimes, but it's knowing when not to do that. It's knowing when to actually, to give a statement. That's the difference between a good lawyer and a great lawyer, I think, is knowing when to cooperate, when to participate, and when not to. And a lot of times it's just a judgment call. There's no clear rule, but in those instances, I'll weigh it. I'll say, okay, what's my relationship with this officer? What has he told me? And a lot of times they'll tell me, and they'll say, look, if he comes in and, he tells us, helps us identify the missing car or the missing motorcycle, where else they may have stolen something from or, how they stole the money, we won't arrest them. We'll just give them a citation or maybe we'll only charge them with one count. Those kinds of things. Or I've also had it. I had a case. This was a couple years ago, but there was a gentleman, I believe he was a pizza delivery guy, and he had been accused. He was doing the nightly drops of the money after they closed down, like all the cash that went into the register. And he had been accused of stealing it because he was the one that took the bag to the bank, right? And he was the last person. We were actually able to go get the video from the bank, and we were able to show that he did, in fact, drop it off. And then on that same video, you saw the manager come back, and somehow he got into the drop and took the money back out after he dropped it, like he knew when he was going to drop it off. I can't remember exactly how it worked, but it was something like that. And with the detective who I knew and was able to work with, he got that video, and we watched it together, and that guy was completely exonerated. So
awesome.
I've had a lot of good experiences working with police. I think lawyers that say all police are bad or you should never work with them, never cooperate, are doing a disservice to their client, even though that may be the default position. Maybe that's where you start from. But this is an area where I think I've really been able to help people. We had another one just recently, a couple weeks ago. I don't want to go into too much identifying information, but it was a person who worked for a governmental entity, and they had figured out that if they requested direct deposit and a paper check, they'd get paid twice. And so they got paid twice to the tune of about $14,000. And in any event, we were able to very much minimize what happened to that person because we were able to pay all the money back. And honestly, that's the kind of mistake that I think that a lot of people could get lured into, right? You ask for the paper check the first time and you realize, hey, I got paid twice. Or I moved direct to deposit. You're like, I'm going to keep getting paid twice. Maybe I just won't say anything, right? Like I've had people ask me like, my employer keeps sending me paychecks after I quit. Is that okay? I'm like, no, that's theft. Don't do that.
Right.
But you can definitely understand the impulse why somebody might think that was, okay or whatever. So anyway, we got a good result in that case. I don't want to go into much more detail, but so that's my kind of experience with this. Do you have any stories you'd like to tell, Abe?
My default answer is always going to be, don't go to that interview. Talk to me first. Let's see where we're at. I want to reach out to the detective and go from there. I think that people that are voluntarily going into the detective's office is never a good thing. And so...
without a lawyer.
Right.
I 100% agree. Don't go down there without a lawyer. I mean, I can promise you that. But at the same time, I think that there are sometimes that cooperation can go a long way. The police are busy, right? And they've got a lot of crimes that they're dealing with. There's a lot of, particularly property crimes and theft and things like that. They would just love to clear off their desk. If your client stole 4 cars, right? And they know about one, I've seen them frequently be like, well, if he tells me about the other ones and I can get them off my desk and we can help him out and, we'll sentence him as though it had just been the one, then that's worth it, right? And so I think that people underrate this. I think this is really one of the keys to, and I know you're not underrating it. I'm not thinking you're doing it. I mean, and I agree. My default is absolutely don't talk to the police without having a lawyer there present, but at least your lawyer should consider it.
Absolutely.
So let's kind of move on to the next kind of phase, and this is what we're talking about a little bit already. It's the idea of arrest versus citation. You want to kind of take over on that? I've been talking a little bit.
Sure. So an arrest is if an officer thinks that they have probable cause against you, they can arrest you if it's a felony, or they can go to a judge and get an arrest warrant. The flip side of that is going to be a citation, in which they give you a criminal summons, meaning that you don't have to go to the jail, you don't have to get booked in. They give you a piece of paper that's going to say you have to appear in court on this date, and so obviously defendants prefer the criminal summons. And what you see in those types of cases is normally those are maybe theft-related cases or a little bit less serious felony cases, and so we always try to push that. If we can influence, if we can talk to the detective, get in ahead of time, that's something that we obviously try to achieve.
And I guess what I would just add to that is that it is so critical for a criminal defense lawyer to have their client out of custody. I think that there's almost no greater predictor of maybe other than actual innocence of what the result's going to be in the case. Because if you're out of jail, you can be working. You can be doing things to improve the situation that led to you going to jail. You can go to rehab. You can get anger management counseling. You can get
work to get restitution.
You can get work to pay back whatever may have been stolen. There are just so many. You can do community service. There's so many things that I've seen. You can continue your education that can really put you in the right position if you are convicted and you are going to sentencing, that we'll eventually talk about. But that's why I think this is really critical too, is if they get arrested, there's no guarantee they're going to be able to post that bond. Sometimes we're seeing initial bonds set at $25, $50, I mean, even nonviolent crimes. And so $1,000, $25,000 or $50,000 for nonviolent crimes sometimes. And that person is probably, unless they're pretty wealthy, not going to be able to come up with that. And so it's critical, it can be critical in this phase to get that citation instead of that arrest. And also, nobody wants to go to jail. I mean, I think that's really, really pretty clear. So after the arrest or citation, you move on to kind of what's called district court. Abe, do you want to tell us a little bit about what district court in Kentucky is?
So district court, their jurisdiction is going to be, that's where all felony cases normally start, and that's where all misdemeanor cases stay. And so in district court, your first court appearance is going to be your arraignment. And at your arraignment, you're going to you should plead not guilty. And at that point...
well, I mean, I guess you can't really plead... I want to take a second to talk about this.
Sure.
You can't really plead guilty at arraignment in a felony case, can you, in Kentucky?
No, you can't. But for misdemeanors, you theoretically could. But at arraignment, we'll plead not guilty.
And the reason to bring it up is you see it all the time in the news, right? The guy's charged with murder and he pleads not guilty at the arraignment, and the news is just like, can you believe it? He pled not guilty. Well, that judge couldn't even take that. If the guy wanted to plead guilty, the judge couldn't take the plea. The district court doesn't have jurisdiction over that kind of case to take that plea. So that just drives me crazy. But I'll let you finish. Sorry.
Sure. So for a felony case, you plead not guilty, and at that point, you would schedule what's called a preliminary hearing. And the preliminary hearing is an opportunity for the judge to make sure there's probable cause in the case. And so what normally ends up happening is the arresting officer will come in and testify as to what the facts or what the reasoning is for the charges. The prosecutor will ask them questions in which they'll respond, and the defense counsel will have an opportunity to cross-examine the officer to get a little bit more of the story. Arguments can be made. You can talk about bond at that time. And ultimately, since probable cause is such a low standard, what you see a lot of times is probable cause being found and then the case being transferred, waived to the Fayette County grand jury.
Okay, yeah. So I want to talk a little bit, kind of unpack some of the stuff you were talking about, the preliminary hearing. Are they required to have a preliminary hearing in Kentucky?
They are not. And so it is a strategical decision, and a defendant can waive that right and just say, Judge, we acknowledge that we have a right to this preliminary hearing. We are not going to have it. We'll take our case to the Fayette County grand jury, and at that time we'll just move forward.
What are some reasons a lawyer might choose to waive a case?
At least here, there are some judges that will increase the bond depending on what the facts are in the case. And so if it's a very serious case, if they think the bond originally set was too low, then you run the risk of that bond increasing once the judge hears the facts at the preliminary hearing.
Yeah, and I guess I would say another couple circumstances in which I think it's acceptable to waive would be in exchange for something. Obviously, I've definitely seen where they'll say, hey, you can have these police reports and these videos early. And if the video, you're going to get them eventually in discovery, but if they have evidentiary value where they're fresh, where you need them now because witnesses' memories are going to fade or cameras are going to no longer be available or whatever it may be, I think it can make sense if you're going to get something. The other thing you can get is bond. I've definitely waived a hearing and let the officer go, not show up in exchange for them to agree to a bond that my client could make. Because like I said, even though that preliminary hearing can be very vital, you're going to get, that's one of your only opportunities you're going to get that detective, get that investigator on the stand and get him under oath before the trial. I mean, in Kentucky, we don't have depositions in criminal court. Very limited depositions in criminal court, I should say. And so, it's a really critical phase, and I think that when people waive it without a good reason, they're really not doing the best thing they could for their client. The other point I was trying to make here was, does the government have to have a preliminary hearing? Is that required, Abe?
They do not. They can do a direct indictment. Is that what you're getting at?
Yeah, a direct indictment and kind of the time rules, if you want to go through that.
Sure. So as far as the direct indictment, it skips the entire district court phase. And so what they do is the Commonwealth Attorney's Office will take a case directly to the Fayette County grand jury or whatever county's grand jury, and they will bring felony charges that way. And so it skips the entire district court portion. Gotcha.
And so that's legal. They can do it. They don't have to have the preliminary hearing.
Correct.
Okay. So are there time limits in which they have to have the preliminary hearings? Can you tell us a little bit about that?
Oh, yeah. So in district court, if the person is in custody, so between the arraignment time and the preliminary hearing time, you have to do it within 10 days. And so that's the in custody timeline.
What happens if they don't have the hearing within 10 days?
They get released.
Yeah.
So they have it within 10 days. And then the other part is, as far as if they are out of custody between the arraignment and preliminary hearing in district court, it's a 20-day. Mm-hmm. But if they're already out of jail at that time, it's very common to see that time limit waived and just pushing it back so you have a little bit more time to prepare.
Yeah, and it's what I tell my clients too. If they do have for some reason there was a 20-day rule issue, you've already posted the bond, and all you really get on the 20 days is you get your bond refunded to you. And if what's going to happen is you end up getting indicted eventually, you're going to have to go back in jail and post bond again. It just doesn't make sense to have it released, I don't think, ever, hardly. But, okay, that's pretty cool.
Some felony cases, and what I tell everybody is that we want to end your case. We want to dispose of your case in district court. And so just because the case can go to grand jury or there,
yeah, this is a good point.
What a prosecutor can do is amend the charge down to a misdemeanor, or they can give you, or they can just flat out dismiss the case. And so what I tell all of our clients is, and there's realistic goals, and there's sometimes it's just not realistic. Like a murder case is not going to, it's not going to be resolved in district court. But in some types of low-level felony cases, what you see is like theft cases where there's not much of a record, or potentially some drug possession cases. In those types of instances, what you can do is negotiate with the prosecutor, drop it down to a misdemeanor, and then you can plead at that time, or you can get a diversion program in which there's some community service involved, and they push it out, and then the case ends up getting dismissed or expunged.
Yeah, that's right. One more point I guess I'd make along those lines is you can actually win the preliminary hearing.
Correct.
It's pretty rare, but it's happened. I've done it. I'm sure you have too.
I have.
It's pretty great when it happens.
Awesome.
Yeah, the judge says, look, the evidence that the government has presented is so weak that I do not find probable cause. And so what happens then, or they could say it is so weak for the felony, but there's still a misdemeanor. That happens too. And what happens is it becomes really kind of dismissed without prejudice. Your client's really just discharged from bond is what actually happens. And they can still be indicted, and in fact, they frequently are after the fact. But it's pretty cool, and it lets the prosecutor know, puts them on watch, hey, they even need to shore up their case, or maybe they want to, maybe they're barking up the wrong tree, want to look somewhere else, somebody else to prosecute. So you just wanted to bring that up because it is one of the sweet, sweet moments of victory when you are a defense attorney, is to win that preliminary hearing. So you were talked already a little bit about the grand jury, and that's our next kind of stage. Why don't you tell the people about what the grand jury is? I think there's a lot of secrecy about the grand jury, and that's intentional. It's supposed to be secret, but why don't you let us know? Tell us about the grand jury, Abe.
So I believe here in Lexington, they meet, is it Monday through Wednesday?
Yeah.
Okay, so they meet
sometimes with holidays, they'll kind of switch it up, but yeah, it's basically Monday through Wednesday.
So it's a group of individuals that they come in every single Monday through Wednesday, and they will meet. The Commonwealth Attorney's Office will present cases to them in which normally either the main witness or the officer will testify, and then that group of individuals will determine whether or not there's probable cause for the case to continue. If you're seeing a theme here, you're seeing probable cause for the actual complaint, probable cause at the preliminary hearing, and another probable cause ruling at the grand jury. And so it's part of just our system here in Kentucky to just there's several checks to make sure cases go forward with at least some merit. But
yeah. So that's about right, yeah. So the grand jury, it's selected from the pool of the people that were called for jury duty that month, and they serve in Fayette anyway for a month. Some counties will serve for 6 months or a year even. And so I believe, maybe not a year, but a long time. And
okay, one option I see nearby is Shallon Stanton Way. Would you like to try that one?
No, Siri. We just had a device. A little technical difficulty. Hey, we were doing pretty good otherwise. All right, well, anyway, I don't think it's picking it up too much. We were talking about the grand jury, and, at the grand jury, the defendant does not get to be there. The grand jury, can choose to hear evidence from the defendant, and the defendant's lawyer can actually write a letter to the grand jury asking to present that under the state rules. Have you ever seen that done, or have you ever done that yourself, Abe?
I have not. It is the big decision that I run across is, should I present my client to the grand jury and ask that they come and testify? And so what you'll see is normally the grand jury will accept that, and they want to hear from the defendant. And so, but the problem is that I cannot be present in the room with my client as he's testifying or she's testifying. And so it's a risk, and the client has to swear to tell the truth, the whole truth, nothing but the truth. And so any statements that they do make to the grand jury could be used in a subsequent trial. And so it's a risk for sure. And so you would have to prepare the client. You would have to make sure that they are approachable, likable, and because it is all recorded. And I have seen some prosecutors some defendants think that they can just outsmart and outtalk and just talk their way out of offenses, and it is ugly.
That's pretty rare. Yeah,
it can be bad.
Yeah, I think nothing convicts people quicker than their own words. And if you're not prepared like you were going to trial, and maybe even better to go to grand jury, then you shouldn't put your client on unless it's a very unusual circumstance. Now, I will say I've had instances where the prosecutors have actually reached out to me and said, hey, you should put your client on because this case is kind of weak. I think the grand jury should dismiss it, but I think it would get them over the hump if they heard from him. And I would say that know your prosecutor before you do that, obviously. But I've never had one do that in bad faith. I don't think they would because they know it's gonna come back around. And everybody's word is everything they've got in the system. If you can't be relied on, if you can't be trusted, then you're not going to be able to operate in this world. So playing some kind of trick like that on a defense attorney, I think would not go well for that prosecutor in the long run.
Well, in Lexington's, it's a pretty small bar.
It's small enough, that everybody would hear about it, and it would not go well.
Right.
And I think other prosecutors and judges would be upset about it too. I will say I have on a number of occasions put my client on, primarily when asked to by the prosecutor, but in a few not. And I think that we need to be more creative about how we use it, because you're allowed to present any evidence. You don't just have an option to present your client. You can say, hey, we've got these bank records, or our private investigator wants to come talk about the people he interviewed, and right? So we can have investigators come in the same way they've got their investigators, and that's a really good way to insulate your client from potential problems if your investigator testifies to it. Now, is it as effective as your client testifying? Probably not, but I've seen it work. And so
the other to play devil's advocate, you're not required to tell the prosecutor any of our strategy at that point.
Mm-hmm.
And so you are putting your cards on the table. You have to think that it is a case that
it better be a good case.
Exactly. Yeah. And so there's a strategical element to it, and every case is different.
Yeah, and then you got to look at it from 10,000 feet. There's some clients that just can't go to trial. So if you can't defeat it at pretrial with motions, you might want to try to defeat it at grand jury, because some clients just can't go through with a trial. I've had people that have had physical disabilities, or you just know emotionally or physically they're not going to be able to withstand the stress. And I know that sounds kind of ridiculous because it's just people getting up on a stand and talking, but unless you've been there, you don't know. So if the grand jury does indict somebody, what's the next phase, kind of, Abe?
So once the indictment is reached, there's an arraignment. So the process starts all over again. You're going to get a prosecutor assigned to the case. You're going to get a new judge that's going to be drawn from all the divisions. And at the arraignment, you would plead not guilty. You would acknowledge that you have received the indictment. You would request formal discovery, and you would have no objection to reciprocal discovery, meaning that we are under an obligation to provide the materials discoverable to the prosecutor and make sure that they get a copy of that. So we have to agree to it. Mm-hmm. And then at that point, we would schedule a pretrial where myself, the client, and the prosecutor would sit down and talk about the case. And then you'd also schedule a status hearing, and that would be the next time that the client has to go in front of the judge.
So pretrial conference is kind of an informal meeting between the defense attorney and the prosecutor and the client. And it's kind of an unusual kind of creature that we have here in Fayette County. I don't think most counties don't do it. It's, in my experience, I've been to about 60 circuits, and I haven't seen it a lot of places. And it's kind of a relic of a time when people were having difficult times getting offers made. The dockets were kind of grinding. It really is kind of like almost like a forced mediation like you'd have in a civil case. And it's I find it to be somewhat productive. I mean, I have a pretty good guess at this point what somebody's going to be offered. Haven't been surprised too many times lately at the first offer. But and so Kind of circuit court it's a different court, a different jurisdiction. They actually can take a guilty plea in a felony case. They can try felony cases. They can hear motions to dismiss in some capacity in felony cases. And so I guess at this point, what are some of the things that you might do after you get to that status hearing, Abe? Do you want to tell us about that?
Well, the big thing in circuit court is you are now given all of the discovery. So all of the evidence against your client, you have a right to that at that point. And so a part of it's just continuing the investigation stage, going through the discovery, finding out the strengths, weaknesses, talking to your client, making sure that you're on the same page with them. You have to share it with the client so they know what's going on. They can help out. I know that we use a team effort, and so we might have several attorneys sit in on a conversation, sit in on a meeting as far as find out what we need to do. And once you can talk to the client, find out where they're coming from, talk to any other potential witnesses that they want you to talk to, go through all of the evidence, police reports, body cams, all of that stuff. Then at that point, you start making strategical decisions as what we need to do next. And so what might be next is a suppression hearing. If the government didn't search right, didn't question right, then we would file a motion and say, this violated this constitutional right and you should exclude it. And so it's, or you can say, well, this is a case that we need to go to trial on. I don't think that they can prove it. And so at that point, you start preparing for a trial. There's some cases where they did everything right, they can prove it, and then we're in damage control. How do we get the best offer possible from the prosecutor?
Sure. And about how long does the circuit court phase take typically here in Fayette County, would you say?
Long. It's not a quick process. You're looking at between 6 months to a year, potentially over a year. I think people are a little bit surprised about just how long it takes. You're looking at, it takes a little bit sometimes to get the discovery. Then it takes a lot of times to work your way through it, find out, be prepared. And if you need a trial, then at least here, the dockets are so congested that it might be 2, 3, 4 months before you even get a trial date.
6 months, yeah.
Yeah.
You know, I was in front of a judge last week that said that they were double, triple stacked on every day until April 1st. You couldn't even be third in line to have a trial some days.
And that just, and whenever you do have a client that's in custody while the case is going on, it just breaks your heart because they are sitting there waiting, and it just it speeds everything up. You try to get done with everything, try to get a resolution as quick, so they're just not sitting there waiting. But if the person is out of jail, then it takes a little bit longer.
Sure. All right. So if the case can be dismissed at this point, obviously, theoretically it can be sent back to district court as a misdemeanor, transferred. I don't see that much anymore. We used to do that a little bit more here. Still happens some. But the other two kind of alternatives, if it's not dismissed or sent back to district court, are going to be you either go to trial or you plead guilty, right?
Yes. And so if you plead guilty, first off, the prosecutor gives you charges and years. And so, or technically months if they go down to a misdemeanor. And so people ask me all the time, well, can I get probation? And unfortunately, I have to say, it's not up to the prosecutor. It's not up to me. It's going to be ultimately up to the judge. So you have to accept the deal first. Then if the charge is probation eligible, then the judge makes the call on whether or not you get probation. And
and that's not true in every county. In some counties, they do negotiated probation. And there's some offenses that have what's called a presumptive probation. But yeah, you're right. I mean, typically here in Fayette County, the best you're going to get offered is we'll stay silent. We won't oppose probation.
Right.
It's kind of I think a relic of the last administration, but things may be changed. We'll see. But I mean, the other alternative, I guess, is for them to oppose probation. And typically, I think their office policy is employee thefts, they oppose probation, and burglaries. I think
violent offenses.
Crimes where, a firearm was used. Now, I think crimes that are actually violent under the law aren't eligible for probation anyway. So I guess they object to that, but they're not eligible for probation anyway. And by violent crime, we don't just mean somebody got hit. We mean a very specific number of crimes that are listed. 439-3401, I think, is a statute that'll tell you all the things that are actually violent crimes. I'm not going to go into that today. I think that'd be a really good video we could do at some other point. But yeah, so you get offered something, you can either go to trial, you can either take it or you can go to trial. And at trial, or we're not going to go into what a trial's like or even what plea negotiations are like today, but you then go to the next phase, which is I think the phase that most people assume is the end, which is sentencing. Do you want to tell us a little bit about how you want me to do it?
Sure.
Let me talk about sentencing. So this is something that's kind of near and dear to me as a former death penalty attorney. We have very, very unique sentencing procedures. Well, not very unique. There are a few other states that do it the same way, but we have unusual sentencing procedures, particularly in jury trials in the state of Kentucky and felony court cases. In jury trials in Kentucky, your actual sentence is determined, or recommended, I should say, by the same jury that finds you guilty. And then you go into a second phase. It's called a penalty phase. In that phase, they'll hear evidence about your past, what prior convictions you have is what the prosecutor will tend to put on. They'll try to prove sometimes it's called persistent felony offender status. And they'll do so to try to argue, depending, and not always, a prosecutor isn't always asking for the highest sentence. Sometimes they're asking for, they say, do what's reasonable. Do what you feel is just here. And I think that I find that admirable that, particularly prosecutors that can find it in their heart to say, hey, this guy went to trial, even though I made him an offer, I'm not going to come here and say, hey, this guy has to get the maximum. I think that speaks to their duty of justice, to be ministers of justice that they have. But yeah, so in Kentucky, you actually call witnesses in front of the jury, and the jury recommends a penalty to the judge. Now, the judge doesn't have to comply with that recommendation. What he can't do is increase it. But there are ways that they can increase it. The judge, if you're convicted of multiple crimes, the jury also makes a recommendation on what's called concurrent or consecutive. A judge can actually reverse the jury's determination that crimes should have been run together and run them consecutive, actually giving you more time than the jury recommended. But what this allows us to do, particularly people that have kind of studied death penalty jury sentencing, because under the United States Constitution, every state and the federal government has to give you jury sentencing on the issue of whether or not you're executed. And so there's been a whole lot of kind of theory and behind this idea of what do you do in a jury sentencing in a death penalty case. It really carries over to the same procedures we have here. Now, that's kind of the sentencing phase of a trial. If you plead guilty and you accept the deal, in all but a few occasions that we're not going to get into, the judge will do the sentencing. They'll follow the recommendation or they won't. Either they probate you or they don't. They may give you what's called shock probation, and we'll probably talk about that in a different video. But ultimately, on your sentencing day, the judge is going to make a determination. Are you serving this sentence in prison? Are you going to serve part of it in a county jail? Or am I going to give you straight probation? You go home, you're going to report to a probation officer. And this is another phase where a lawyer can be absolutely critical. I have filed 91 100-page sentencing memorandum in state court. And, if you go in there and you say, look at all the great stuff my client's done, the judge, is supposed to look at three factors in addition to the character and fitness of the defendant. And those are in making the determination on whether or not a person should be sent to prison. And those factors are hold on, give me a second. One of the factors is, would giving probation unduly depreciate the serious nature of the offense? Another would be the character and fitness of the defendant, as I said. And the other would be, would the defendant be best served by the type of rehabilitation supervision that would be provided by the Department of Corrections in a facility? And so as your lawyer at the sentencing should be making arguments to say, hey, your character and fitness shows that you don't deserve this. You would not be best rehabilitated, and one way to do that is to get them rehabilitated before sentencing, whether it be rehab, paying the restitution, what have you. And then finally, the one that I think is determinative for most defendants is, would it unduly depreciate the serious nature of the offense? And that's what I see a lot of judges look at. And so obviously every felony is serious. So what does it mean to unduly depreciate? And you get into these kinds of arguments. But ultimately, that's kind of my spiel on sentencing. Do you have anything to add, Abe?
Yeah, sure. So between the guilty plea or the conviction and sentencing, we routinely have a meeting with the client. And so it's really important for the client to look in his best presentable, because this is a huge decision the judge is about to make. So first off, dressed well, church clothes, whatever you have, jacket, tie, respectable dress, whatever it may be, That's what I would recommend. Then you get into letters from family, friends, employers, because I do think that carries some weight. Judges consider it, and what we do is we will file a probation motion, and we like to have all our clients to give us those letters first. Then we will submit them all at the same time.
Mm-hmm.
And so not only are we giving a plan and why our client should get probation with the judge, but then we're also giving friends, family, employers. And that's another thing. Judges love jobs.
Sure.
And so if you have a job, that is good. If you don't have a job, get a job. And so I'll tell that to all my clients, because that's one of the first things that they'll say is, are you in school or are you working? And so being a productive member of society, it doesn't matter where you work.
100%. In fact, I think sometimes if somebody has gone from some lofty position to where you tell a judge this happened and now he's at McDonald's, like I think that's, pulls at their heartstring a little bit, to imagine what that must be like for somebody. So I tell people, get a job. If it's, cleaning gutters, do what you got to do.
Do what you got to do. There's one judge in particular here. She calls her probation program the Get a Job program. Mm-hmm. And so you have to do it. And so that's one thing that you need to do. So those are just a couple things that we focus on between the guilt phase and the sentencing phase to put you in the best position to get probation and get that opportunity. Okay.
Well, I think that pretty much sums up the portion of the program that's in circuit court. Now, there's shock probation we can talk about in the future. There's post-conviction, ineffective assistance of counsel, direct appeal. We'll save those for other videos. Do you have anything else you want to tell the people out there before we sign off today, Abe?
Let's see here. I would think that if you are charged with a felony, it is obviously extremely, it's got a lot of consequences. There's writing, your right to vote, your Second Amendment rights. Obviously, the biggest thing is the job, and so it's just a big decision, and it's a bad place to be in. It's one of the most stressful things somebody could possibly happen in their life, and so it's right to have. It is the best to have counsel that you respect, that you get along with.
Hire a lawyer. That's what, if you're charged with a felony, if you're charged with any crime, hire a lawyer. But particularly if you've got a felony, hire a team of lawyers, a very good team of lawyers, like the team here at Baldani Law Group.
You can do that, yeah.
All right. So in any event, I'd like to thank you guys for watching. As always, I'm Bradley Clark. This has been Abe Mashney with Baldani TV. If you guys have any comments, please leave them. Remember to like. If you didn't like it, you can leave that little red mad face. I don't know. Just respond. Let us know what you think about this. Should we be doing this? Is this cool? Do you enjoy it? Do you want to be on the show?
Ideas.
Let us know. Ideas. Yeah. What do you want to hear about? Do you want to hear from, people that have been to prison? Do you want to hear from probation officers? Who do you want to hear from? Let us know. And we'll get Tucker or Russ on here before long for those of you that know him. But those of you that don't, you will before long. So anyway, that's Brad Clark signing off. Anything else you want to say, Abe? Or are we out?
We're out.
We're out. Peace, y'all.